Hello and welcome to this podcast on the English and Welsh legal system with Dr. Ryan Murphy. Today we are going to be considering the role of lay magistrates in the English legal system. And the purpose of the podcast is to consider what an important role that magistrates play and the general desirability or otherwise of involving lay people, essentially lay people, in the administration of justice. We're going to look at the historical context, we're going to look at the substantive role, given that magistrates play such a prominent part in the administration, particularly of the criminal justice system. And so, without further ado, let us make a start in running through the context and history involved in the use of lay magistrates. And so lay magistrates are also known as justices of the peace. And so in more formal documentation, you may come across the term justice of the peace, and they essentially mean lay magistrates. Now, lay magistrates are essentially local citizens sitting and adjudicating on largely criminal matters at the lower end of the seriousness of criminal offences in the English and Welsh legal system. That, like much of the legal system in England and Wales, they evolve and they have a long-standing history. And so the role of the JPs, Justice of the Peace, have evolved from the 12th century under Richard I. And so they have a very, very long pedigree. And as we'll explore, the role has evolved over time, but it's been present now for many, many centuries. So one of the initial things to point out is that you may come across in older literature a phrase called stipendiary magistrates. These are essentially fee-paid magistrates who now are referred to as district judges, open brackets, magistrates' courts, close brackets. And it's important to realise that the focus here, the focus of this podcast, is largely on the role of lay magistrates, not of these, what used to be called stipendiary magistrates, and that are now called district judges. They hear cases that are primarily criminal, although they do have a role to play in youth justice and a more limited role in family matters. But for our purposes, we're going to focus largely on the role that they play in the criminal justice process. And they are a vitally important aspect of the justice system, the criminal justice system of England and Wales. That's because all criminal cases start their life in the magistrates' court, many of which start their life before these so-called lay magistrates. And so they are, in some ways, the workhorses of the criminal justice system. They perform a vitally important role in the administration of the vast majority of criminal cases. And although some criminal cases will end up in the Crown Court, a very, very large proportion of them will remain within the Magistrates' Court and will be dealt with by lay magistrates, the justices of the peace. And their roles and powers have evolved over time. So traditionally, in the 1100s, so in the 12th century, they did have their own powers of arrest. And we've moved away from that being the primary role of the magistrate as keeper of the king's peace. You know, for somebody who investigated crime and actually arrested people, through powers of investigation of crime, to what they predominantly do now, which is to perform a judicial or a quasi-judicial function of adjudicating on cases. And so the first point to note, if we're going to take a more general lesson from this history, this very, very brief history of magistrates in the legal system, is that, like the rest of the legal system, they have evolved over time. They've changed over time in the same way that the role of the jury has changed over time. The role of officers of parliament have changed over time. So this is also true of the lay magistracy. They are an unpaid aspect of the criminal justice system. So they get expenses, which does include an amount for a loss of wage, but that this is a capped amount. And so in some ways, this is a throwback to an era of cheap local justice. That's essentially one of the biggest selling points of magistrates, is that they have an understanding and a knowledge of the area from which they're from and in which they sit. And also, they are cheap. So a trial by magistrates, if you were to do it on a daily rate, is cheaper than a trial in the Crown Court with a jury and in front of a full-time judge. And so what we can start to see is that even if there are imperatives to change the system of lay magistrates in England and Wales, this has to be sort of laid over with concerns about what that would do for the cost of justice. And so magistrates maintain a cheap system because, as I say, they are unpaid. They must make a commitment to sit for at least 26 half days a year. Many magistrates combine this into full day sittings, but one of the commitments of becoming a magistrate, even though it's unpaid, is that you must sit for at least 26 half days a year, up to a maximum of about 70 half days a year. And so the time commitment is small but significant, if I can put it that way. Let's then think about how you become a magistrate, a lay magistrate. What qualifications do you need? Are there any people who are disqualified from sitting as magistrates? And how can magistrates be removed? All of this information you can find on government websites. You can also find it on the page of the Magistrates Association. And so you can find a great deal of this information out online in your own time, but just to give you some of the headlines. The first one, which is surprising for some people who are new to the English legal system, is there is absolutely no requirement for a magistrate to be legally qualified. Being legally qualified isn't a bar to becoming a magistrate. It doesn't stop you from becoming a magistrate, but it's not a necessary condition. You don't need to hold a law degree. You don't need to hold a practicing certificate. You don't need to have any form of legal qualification. You are given training, and also magistrates are supported by legal advisors, by clerks who inform them as to the relevant law to be applied. And so one of the qualifications that you might have guessed, had I asked you to guess, as to what qualifications would you need to sit on actual criminal proceedings with powers to send people to prison, what might you be required to have in terms of qualification? People might have thought you need to be legally qualified, but you don't. You need to be aged between 18 to 65. The actual maximum age by which you need to retire as a magistrate, and if you do retire, you can go on the supplementary list, but generally speaking, or quite strictly speaking, the maximum age that you can serve as a magistrate is 70. But someone is very, very unlikely to be appointed as a magistrate when they're over 65, because by the time you've gone through the training and the consolidating training and all the rest of it, you would have very few opportunities to sit. And so the potential is from 18 to 65. That in order to become a magistrate, you need to demonstrate that you have certain key qualities. You don't need formal qualification, you just need to demonstrate that you have these key qualities. That you are of good character, and that means that if you have a criminal conviction, for example, or you are a undischarged bankrupt, then it's unlikely that you will be selected to be a magistrate. You must demonstrate that you have understanding and good communication skills. You must have a social awareness. The the societal issues that exist in the broader community in which you serve. And one of the great banners for magistrates is that they have a connection to the local area. So an understanding of social awareness is a key requirement or a key quality if you are to become a magistrate. You must have maturity and be of sound temperament. That you must be able to demonstrate that you can exercise sound judgment. And we'll come on in a little bit to talk about what is the process of appointment for magistrates, but the process for appointment systematically tests that you have these key qualities, and that you can demonstrate that you are reliable and that you are committed to the very important civic function that you'll perform as a magistrate. So originally, and for a very, very long time, one of the great benefits, or the perceived or the claimed benefits of the magistracy, is that they have a connection to the local area in a way that a judge on circuit or a judge serving a wider, broader area wouldn't have. And so until the Courts Act 2003, you had to reside in the area in which you sat, which was a defined area, or within 15 miles of that area. Now, there is still an attempt to link to the local community, in the sense that you must now reside within the court in which you sit, the magistrates' court in which you sit, must be within a reasonable distance of your workplace or your residence. And one of the reasons that this requirement has been loosened slightly is because it's become increasingly difficult to recruit magistrates. And so the government has gone to the extent, or the legal system has gone to the extent, of advertising for magistrates, particularly those within the younger age brackets. And so one of the ways of easing on that, and recognizing that people commute, that people move around a lot, that people don't live in the hubs that they used to live in, is that loosening of the requirement to reside in or within 15 miles of the local justice area. So now you must live or work within a reasonable distance from the place in which you will sit. That it's not easy to remove a magistrate, but you can be removed by the Lord Chancellor and the Lord Chief Justice acting in concurrence, so acting together, that you can be removed. There are then certain categories of person who are disqualified from sitting as a magistrate, and that includes those who work for the prison service. You're seen to or there might be a perception that you are biased if you work for the prison service. Those who are involved, traffic wardens is just one example, those who are involved in the enforcement of certain laws, it would be inappropriate for those to sit in judgment on those laws. It's a separation of powers argument, in essence, that those who administer justice should not also be those who execute the law. So you separate off the executive function from the judicial function. The same goes for police officers, and even those who were recently retired. So serving police officers are disqualified, as are those who recently retired from the force. Again, those who might be involved in the enforcement of judgments, and that would include bailiffs, they are excluded from sitting as magistrates. And so what you see is it's a fairly broad, open field, if you like, that you need to be aged between 18 and 65. You need to demonstrate the key qualities, and you need not be on the disqualified list. And as I say, one of the challenges facing the legal system at the moment is a lack of volunteers to become magistrates, lay magistrates. And it might be worth just pausing a moment and thinking about the reasons why it may not be that attractive at a role anymore. Why is it that people don't wish to become a magistrate? And think for a second, and we'll come on to this in a little while, think about what is the profile of the person that you think of when I say lay magistrate to you? Is there a certain age profile you think about? Is there a certain ethnicity? Is there a certain professional status that you think about when you think of the magistracy? But if you are eligible to become a magistrate, then there is a selection process. You fill in an application form. The application form will capture certain key personal information and certain motivational questions that will start to see whether you are eligible to sit. There will be an initial interview. The initial interview will seek to test your attitudes towards the criminal justice system. It will seek to elicit whether you demonstrate, whether you can demonstrate that you have those key qualities that are necessary in order for you to become a magistrate. And then that's followed up with a second interview. And the second interview will involve talking through the sorts of cases that a magistrate is faced with. So there will be certain practical exercises to test your critical functions, to test your reasoning, to test your ability to be able to apply legal principles to a set of facts. You are then recommended by a local advisory committee, and if you go on the government's public appointments website, then quite often these local advisory committees are actually actively advertising for magistrates. And then appointment is, according to legislation, is the responsibility of the Lord Chief Justice. So the leader of the courts in England and Wales, the most senior judge in England and Wales. And at present, that power of appointment has been delegated to the senior presiding judge in England and Wales. And so whilst the legislation names the Lord Chief Justice has delegated those powers a little bit lower down the judicial hierarchy. If you are successful and you are recommended and appointed as a magistrate, then the next stage that you will go through is some formal and informal training. So this is overseen by the same body that oversees training of the judiciary more broadly, and that's the Judicial College, which replaces the older institution which used to deal with judicial training. But the training for magistrates is technically overseen by this Judicial College. It's administered much more locally, but overseen by the Judicial College. And then there is a formal package of training from the outset, and that includes an induction, a prison visit. It includes court observations, normally at least 2 court observations, and that is supplemented with other sort of induction type activities. That all magistrates are subject to a formal appraisal. Formal appraisal can be by another magistrate who's trained in that purpose. It can be by others. But there is a formal appraisal system of the work, the skills, knowledge, and expertise, judgment of new magistrates. Then after about a year, new magistrates will go through consolidation training, which sort of refreshes them on some of the earlier training that they've gone through. And then there is periodic updater training that magistrates are required to undertake. So this might be on changes to rules in civil and criminal matters. It might be on a whole host of other things, but there is this formal ongoing requirement to remain trained. If we then look to the function of magistrates and the magistracy, it performs its most important function, arguably, in criminal cases. So the initial step of every single criminal proceeding in England and Wales starts in the magistrates' court. And there is a very good chance, if you're not before a district judge who's sitting alone in a magistrate court, that your proceedings will start with lay magistrates. And so they have a heavy burden of responsibility of the initiation of the court part of all criminal proceedings in England and Wales. That they deal with some preliminary matters like bail. They deal with what we would call summary offences. So those are offences that are heard only in the magistrates' court. So not only will they start those proceedings, but they will see those proceedings through right to the end, right through to sentencing. That if the magistrates claim jurisdiction in a either way offence, so this is an offence that might be tried in the magistrates' court or it might be tried in the Crown Court, and the defendant does not elect for a Crown Court trial with jury in an either way offence, then actually the magistrates will deal with, the lay magistrates in the magistrates' court will deal with even some of the more serious offences, provided that they feel that they have adequate sentencing powers. They will deal with the entirety of those offences. Generally, ideally, they sit as a bench of 3. So you will have a chair who is the only one who will speak and ask questions in court, but they are accompanied by 2 wingers. And when it comes to decision making, all 3 magistrates on a bench will all 3 on the panel will have an equal say. Now, because of the problems of recruitment of magistrates, it is possible, it's supposed to be exceptional, but it is possible for 2 magistrates to sit on, for example, a trial. And the problem with that is if they are tied, if one votes one way, one votes the other, one finds guilty, one finds not guilty, then you'd have to have a retrial. And so most judicial proceedings, there is an attempt to get an odd number of judges. So that prevents that from happening. But because of the dire need for magistrates, panels of 2 have become much, much more common than they once were. And as I mentioned previously, those the bench is supported by a clerk, and the clerk will have legal qualifications. So the clerk will be able to advise magistrates on the law in a particular case. And the magistrates are supposed to take good account of the advice of the clerk on the law, and then they apply that law to the facts and they make findings based on that application. So that's broadly speaking what their function is. As I've said, they also have a function in terms of family proceedings and in terms of the youth court. But by and large, magistrates are concerned with, consumed by, and are leaders in criminal law. If we then think about diversity in the magistracy, then actually, although if I were to ask people in the street, what do you think of magistrates? Describe to me a magistrate, then they would probably describe a white, older, male professional. That's the view of what the magistracy is and of how the lay magistrates are composed in terms of diversity. And that was certainly true 20 or 30 years ago. And it's certainly true in the media presentation of lay magistrates. But actually, on certain measures, lay magistrates are a diverse group of individuals. So they are diverse in terms of ethnicity. They are performing better in terms of the representation of BME members. They are doing better on the measure of gender. So last time I looked, it might have changed now. There were more female magistrates than there were male magistrates. There were more women magistrates than there were men magistrates. And so they're not doing half bad if you compare them to other levels within the judiciary. The one area that they do particularly badly on in terms of diversity is age. So this is perhaps unremarkable, but the vast majority of magistrates are currently over 50. And if you think, this is hardly surprising, if you think that this is an unpaid role where you have to commit a substantial portion of your time, and so it's not unsurprising that the magistracy is made up of many, many retired people who had a professional role in life and are looking to give back to the community in their retirement. And that's another measure on which the magistracy doesn't do particularly well, and that's socioeconomic measures. So the vast majority of magistrates are from socioeconomic groups that largely contain professional people. Again, this isn't that surprising. So if you are in a profession, it may be easier for you to take time off, to be flexible in your working life in order that you can perform the important civic duty of being a magistrate. And finally, before we leave, what I want you to do is just to think. So this was a very, very short, very truncated examination of the magistracy. So go away, do some research on some of the themes that we've talked about. What is the purpose of lay magistrates in the legal system of England and Wales? Do they play a positive role? And in what ways can their role in a modern legal system be sustained? In what way are they an acceptable aspect of the legal system of England and Wales? And so what I would like you to do is to consider the following question. To what extent does the system of lay magistrates in England and Wales contribute positively to the administration of justice? So think of the advantages that they bring in terms of local knowledge, in terms of what are the advantages of involving lay people in the administration of justice. And perhaps you can cross-reference that with some of the arguments that people make in support of jury trials, which again involves an aspect of lay administration of justice, lay people involved in the administration of justice. Equally, think of some of the problems that it causes in terms of, is it efficient? Is it cost efficient? And is it appropriate to have those who are not legally qualified essentially adjudicating on legal disputes? And does the progress in certain areas of diversity mean that we don't need to worry that magistrates are from a certain socioeconomic grouping predominantly, or from a certain age group predominantly? So those are the sorts of things that I would expect you to think about in preparing an outline to that question. And that's really all I wanted to talk about today, was to bring to your attention the importance of the magistracy in the administration of justice in England and Wales, and to start to critically consider the role of magistrates now and in the future. Thank you very much indeed. Goodbye.